Hello and welcome back to the channel. Today, we'll be discussing about how to file a trademark registration application in Malaysia. First of all, we'll begin with manual filing of a trademark application in Malaysia. The requirements for manual filing of a trademark application in Malaysia include 2 copies of the completed application form. Out of these 2, 1 copy is returned to the applicant for future reference. Size of the trademark should not exceed 10 cm by 10 cm. The payment of the statutory fee is Malaysian ringgit 950 per class, provided the list of services or goods applied has been adopted from the pre-approved list of services and goods. There is a provision for the cancellation of services and goods if they are not found to be the same as claimed in the application. The statutory fee for the trademark application is Malaysian ringgit 1100 if the class of services or goods is not adopted from the pre-approved list. In case the trademark is in series, then an additional fee of Malaysian ringgit 50 shall be charged for every second and every subsequent trademark. The applicant has the option of applying for more than one class in one single application, that is, application under multiple classes in one application is permitted in Malaysia. The payment for the statutory fee can be made either by check, cash, credit card, bank draft. Let us now discuss the online process of filing a trademark application in Malaysia. Following is the 8-step simple application process of filing an application for trademark registration in Malaysia. Step 1 involves designing of a trademark. Designing a trademark is the most elementary thing in the process of trademark registration in Malaysia. The trademark should be made in consonance with the applicable provisions of the Malaysian trademark law. A trademark is not restricted to logos only. According to the definition of trademark in the Trademarks Act of 2019, a trademark includes a sign, alphabet, letter, numeral, name, series, brand device, label, ticket, heading, packaging, or a combination of them. The trademark should be such that it is capable of being represented graphically, and it should be capable of distinguishing its services and goods from those of others. The trademark should also fulfill all the requirements under the Trademarks Act of 2019, especially in terms it should not fall under the absolute or relative grounds of refusal. Step 2 involves determining the classification of goods services to be trademarked. It must be remembered that the trademarks are protected in relation to the services and or goods. Therefore, it is necessary to decide the exact list of the services and or goods that are being offered or will be offered under the trademark. After deciding the list, the relevant class of services or goods under the niche classification has to be determined. This is a crucial step in the registration of trademark because this helps in determining the scope of protection of the trademark. It must be noted that the protection of trademark does not extend to goods or services that have not been covered under registration. Therefore, the trademark consultants at Enterslice strongly suggest covering as many classes as possible. Step 3 involves conducting a pre-filing trademark search. Generally, it is suggested that before filing the application for registration of a trademark, a pre-filing trademark search and analysis must be carried out in order to find out whether a similar trademark already exists under the same or similar name or not, and also to find out the chances of obtaining the registration under the decided mark. This search for trademark focuses on the marks already registered in the trademarks registry. The search can also be extended to cover databases in other jurisdictions as well. This search is entirely optional and not forms part of the official registration process. The applicant also has the option of making a request for pre-filing trademark search to the Malaysian Registry of Trademarks. Generally, the Malaysian Registry often takes a time period of almost 1 year to issue a decision on the existence of a similar trademark. Therefore, it is advisable that trademark services offered by Enterslice must be availed before making the application of trademark registration. Fourth step involves identifying the trademark owner. In the next step, it is important to decide on the trademark owner because the same has to be mentioned in the application. The trademark owner can be an individual or a juristic person also, such as a company or other organization. It is advised by the trademark consultants at Enterslice to think thoroughly about the ownership of the trademark because the cost of transferring the ownership of trademark in future is very high. Fifth step involves filing of the trademark application. After deciding the ownership, class of goods and services, and the list of goods or services, the next stage begins with the compilation of documents that will be required to be attached to the application for trademark registration. It is always beneficial to consult the trademark consultants at Enterslice before filing the application in order to avoid unnecessary refusal or office action. Once all the information has been compiled, the applicant move ahead with the application by filing the required information in the prescribed forms and the payment of the statutory fee. After the application has been filed, the applicant cannot use the registered symbol till the registration of a trademark is concluded. It is an offence to represent a trademark as registered without getting complete registration. The maximum fine for the commission of this act is Malaysian ringgit 10 million. Sixth step involves examination by the trademark examiner. After filing the application, the registrar of trademarks will verify the documents and the information submitted in the application. This examination by the registry is known as the formality examination. If the registry finds out any irregularities in the application, then an opportunity shall be provided to the applicant to respond and rectify the irregularities. Once the formality examination is completed, the registrar proceeds to conduct a substantive examination of the trademark to determine the registrability of the trademark as per the requirements of the Trademarks Act of 2019. The registrar usually takes about 6 to 12 months to examine a trademark application. 7th step involves publication of the mark in the Malaysian IP journal. If the registrar finds that the application fulfills all the necessary requirements specified under the Trademarks Act of 2019, the trademark is accepted and the registration procedure moves towards the advertisement of the mark in the Malaysian IP official journal. Within a period of 2 months from the date of advertisement, the public is given an opportunity to dispute and oppose the mark. In case anyone from the public opposes the trademark application will be transferred to the separate opposition proceedings for determining the registration. This process involves filing a notice of opposition, exchange of statutory declarations, counter statement, and legal submissions between the parties. However, if no opposition is filed, then the trademark will be registered in respect of the services or goods. The final step comprises of registration of the trademark. Upon registration of the trademark, the registrar issues to the applicant a notification of registration of the trademark with the seal of the registrar. The registered proprietor or the owner of the trademark has the option of requesting a certificate of registration which shall be equivalent to the notification of trademark. From this point onwards, the registered proprietor has the option of using the registered trademark. For more such information, please subscribe to the channel. Thank you.